first, good afternoon. I am Eric Stumpus. I'm the marketing director at Fraser, Trebilcock, and I'd like to thank you all for joining us today for this webinar on the topic of cottage succession planning, aka cottage law, where Mark Kellogg, the attorney, will help you better understand what cottage planning and succession is, why it is important, and the benefits of creating a plan for your family's future generations. Throughout this webinar, if you have any questions or comments, you can type them in the chat section in Zoom, and we'll answer them as soon as possible. I'm the moderator, so I'll be checking, periodically, and I'll stop Mark if he doesn't see those, any of those comments. Lastly, if at any point you do need to leave, don't worry. We will have a recording of this webinar in full to share, available tomorrow. I'll just have to edit it after this, and I'll upload to YouTube. I will send out a link to all participants' emails, so you'll have that tomorrow. So without further ado, Mark, you can go and take it away.
All right, thank you, Eric, and hello to everybody. We all have a new meaning of Zoom nowadays with this pandemic, and I don't think most of us probably had no idea what that was up until a few months ago. But I appreciate the opportunity to be able to talk to you, at least this way. As Eric said, I'm with the firm of Fraser, Trebilcock. We have an office in Lansing, Grand Rapids, and in the Detroit area. I work with families actually throughout the country and actually in Canada on cottage law and cottage succession planning. It's been the biggest focus of my practice over the last probably 5 or more years. And I would, and so today, it'd probably take about an hour, but I like to kind of share with you issues that might involve planning. As you probably know, and you're here listening for the reason that a lot of cottages and vacation properties that I'm assuming you have, that is a significant asset to the families, has a lot of emotional ties and memories and everything else. And so it's important, I think, that you consider planning as you look at this, as you get older and how you want to deal with your property. And again, most cases, people want to keep it in the family and pass it down. So I'll get started. And again, thank you for the opportunity, and we'll get going here. And like Eric said, feel free if you have a question in the middle of the presentation to get his attention, and I'd be happy to answer it as we go. You don't have to wait till the end or anything else. So the topics I'm going to cover basically today: Michigan real estate taxes. That's a big issue in Michigan. And I'm sure most of you probably have heard of the term uncapping. So that's a significant part of planning when you're dealing with Michigan real estate. There's 2 states in the country that have a similar type tax structure, California and Michigan. So we don't compare to California a lot of times, thank goodness, but in this particular case we do. Cottage planning issues, usually the goals of cottage participants, what those goals are, some real estate principles, and then finally some solutions. So the first topic of real estate taxes. I'll give you a brief history on Michigan and why we're where we're at right now. But in 1994, Proposal A passed. And at that point, it developed a dichotomy between assessed value and taxable value. So for the assessed, for annual property for the assessment, just a second here. No, didn't mean to advance there. So proposal A, like I said, it was passed in 1994, and annual property assessment increase is capped and cannot exceed the lesser of 5% or the rate of inflation during the preceding year. So that's the taxable value. And when the ownership of property is transferred to a new owner, the property value is uncapped for purposes of calculating property taxes, and the value is adjusted to the current fair market value. So we have, if you see your tax statement, you have an assessed value and you have a taxable value. And your actual taxes that you pay is based upon the taxable value. Here's a graph that I'm putting up here, and you'll note that there's the gap has increased over time between the taxable value and the state equalized value or assessed value. When I say state equalized value, that's the same thing as the assessed value. I will note that this gap tends to be even greater with regard to cottage property, lakefront property, those types of properties. It's increased dramatically over, since 1994. So oftentimes clients I work with, they have a significant gap between the assessed value or SEV and the taxable value. So again, under the Michigan property tax system, the property taxes remain capped until there is a transfer of ownership. And the term transfer of ownership is defined by statute. And it can be very complicated. I won't get into all the details, but know that some events are considered transfers. That our transfers are not transfers of ownership for the uncapping statute purposes. And some events that should not be transfers at all are deemed to be transfers of ownership. So you could get yourself in trouble if you just make transfers for legitimate reasons, and they could result in uncapping. So let's talk about transfers of ownership and what they include. Just a second here. So the following are transfers of ownership unless the new owner is a qualified family member. A conveyance by deed or land contract, conveyance to a trust can be a transfer of ownership. Conveyance from a trust, so a distribution from a trust. Inheritance from a will or a trust, the change of a present beneficiary of a trust. As the bullet point notes on here, this is perhaps the most misunderstood provision of the law on uncapping. And the transfer of ownership interest in a entity, a limited liability company, corporation, or other entity, when the transfer on a cumulative basis is more than 50% of the ownership. That can be a transfer of ownership. So this has significant consequences, and we deal with this, and I work with clients when we talk about cottage planning or succession planning. So transfers of ownership do not include the following: a transfer to a spouse or jointly with a spouse, a transfer to a qualified family member, and this is a certain relationship to the transferor. Transfer subject to a life lease retained by the grantor or the transferor. When the lease terminates, if the grantee is a qualified family member, again, that's not a transfer of ownership. Transfers to a trust if the settlor, the creator of the trust, the settler's spouse, or a qualified family member is the present beneficiary of the trust. So what's a qualified family member? I've used that term in a couple of occasions. Well, right now, by statute, the following are qualified family members: the transferor, a spouse of the transferor, or the transferor's or the transferor's spouse's mother or father, brother or sister, son or daughter, including adopted children, and grandson or granddaughter. And this will have some significance as you're dealing with planning. So this is just another planning method that's outside the statute. And again, I won't go into detail other than to mention there is a joint tenancy exception to uncapping. So under this case, Klooster versus City of Charlevoix, the Supreme Court ruled that neither the creation of joint ownership with rights of survivorship nor the subsequent death of the original owner results in uncapping of the value of the property for tax purposes. So there is some planning we can do outside the statute if the property is held by the people as joint tenants with rights of survivorship. So let's get into now, after that brief history of uncapping and why it has some significance in this planning and probably for you, into some cottage planning issues. So number one is, how do participants of the cottage view the cottage? I can imagine most of you view it as item B here, but is that always going to be the case? And as the property gets transferred down to heirs and further generations, is it an asset of considerable economic value? Or is it a retreat for family enjoyment to be preserved for future generations? So how you answer that question will certainly dictate and how you determine the plan for your property. A cottage plan. What is a cottage plan? It's an agreement that describes how a cottage will be shared, managed, and passed on to future generations of family members. So the overview of a typical plan. Who should own it? Who should be the eligible owners of the property? Who should manage it? Who should pay for it? Pay for the costs associated with owning the property, maintaining the property, and using the property. What if an owner wants or needs out? Who gets to use it? And how should use be scheduled? So typically my plan will deal with all these issues and discuss and provide a way that each of these are handled. So cottage lingo that I'll use in my discussion. You have the founders, and many of that may be you, the initial people who either bought the property or maybe a generation above you, maybe your parents, or in some cases, maybe even your grandparents. But the founders were the initial owners of the property. And then you'll see there's a second generation here and then a third generation potentially. And we will often, in my plans, and as I discuss this, we'll talk about branches. And typically that would be, if you have a mother and father, each child would be a separate branch. So in this case, we'd have Andy's branch, who's a son, Bob, who's a son, Bob's branch, and Carol, who's a daughter, and Carol's branch. And that branch concept oftentimes will carry through to down the generations. So typically, what are the cottage participants' goals? Well, number one, normally it's keep the cottage in the family for generations so that it can serve as a gathering place for the extended family. Give children equal shares of the cottage, but in doing that, avoid trapping an inheritance in the cottage. Keep interest in the cottage out of the hands of in-laws and creditors. And reinforce the family interest and any one individual's interest. So that's typically the goals of the founders as we look at planning for your property and cottage. What are the goals of the heirs? So the heirs would be those who receive the cottage from somebody. So as you pass it down to your children and goes down generations, what oftentimes are those goals? Protect the cottage in the event of a divorce. Develop this decision-making structure and control mechanisms. Develop consequences for failure to abide by rules. Those rules can relate to the financial rules that are set up as well as behavioral rules. Develop a fair, flexible scheduling system. So as the heirs gets bigger and bigger, there may be issues on usage and how it can be used, and so you develop usually a scheduling mechanism or system, and potentially have the ability to sell the interest back to the family. So I'm going to cover some real estate principles that will highlight, I think, why you may want to consider entering into a cottage plan. So, title to the cottage without a plan. Oftentimes, the husband and wife will hold title to the property as joint tenants with rights of survivorship. Under this scenario, and this is typically at the founder level, title of the property will automatically pass to the survivor on the death of the first co-owner, regardless of any provision in a will or trust. If you hold property as joint tenants with rights of survivorship on the death of one of the co-owners, so let's say the husband passes, by operation of law, the ownership of that property would pass to his wife. Again, title to the cottage without a plan for heirs. So most children and cousins would hold title to the cottage as tenants in common because they receive a share of the cottage either as an inheritance on the death of the founder, as a gift, and a gift would be during lifetime, or as a distribution from a trust if the founder has set up a trust and that's part of their estate plan. So let's talk briefly about the tenancy in common rule. So if you go back to what I said, that oftentimes heirs will receive the property as tenants in common. So what's that mean? Each tenant in common has a right to partition. So what that means is if there was a problem and a person who owns it as a tenant in common isn't happy about what's going on with the property, the right to partition is a right to go to court and have the court separate the property. And I'll talk about that a little bit more in a second, but each tenant in common may use the cottage at any time. Again, no rules, no organization. They each have a right to use the cottage at any time. A tenant in common may transfer his interest to any person at any time, including his or her spouse. So with a tenant in common, there's the high risk that the property will go outside of the family at some point in time. And a tenant in common does not owe rent to the other owners for using the cottage. They have an inherent right to use it by being a tenant in common, having a tenant in common interest. So my little graphic there, tenancy in common means, in many cases, that trouble is coming. So that's not an ideal way to hold the property. So let's talk about, well, let me go back to partition for a second. I said I would discuss that briefly. So what partition means primarily is, again, if there's a dispute or a conflict among family members and someone wants to take advantage of this right to partition, you typically go to court and have the court deal with the property. And partition actually means dividing the property. So if there's 3 siblings and they're fighting about the property, they go to court on a partition action, and those siblings are asking the court to partition the property. In its actual terms, partition means cut the property in thirds, and each person gets a third. So that's back to historical real estate law. And so if you have vacant land, that might work. You cut the vacant land in 3 pieces. Everybody gets their own piece individually, and they go on their way. But that's a little bit difficult to do if you have a cottage on the property. You can't really cut the cottage in 3 pieces and say, okay, you stay in this third, you stay in this third, and you stay in this third. So it's really not this partition action, really, most times when you have improved property, is a forced sale of the property. So unfortunately, if this, let's say the property was in the family for 50 years and it gets to a generation where they can't agree on things and they're fighting about things, and one of them goes in and tries to initiate a partition action, the risk is that that property the judge could order a forced sale of the property, and potentially it could leave the family, which is what most people do not want to have happen. So let's talk about planning. There are different ways of planning, and I've done all of these with clients. It just depends on their objective, what they want out of the planning, and how formal they want this planning. But you could have a co-ownership agreement. And this may be used if tenants in common, if those tenants in common, if the cottage may be sold soon, or it may be sold down the road and they're anticipating selling it, you enter into this agreement that deals with the cottage. One of the downfalls or aspects of this co-ownership agreement that is not favorable is that only those people who sign the agreement are bound by its terms. So a co-ownership agreement is not great to deal with subsequent generations. So it's better usually to avoid this issue of tenancy in common and tenancy in common ownership. One way to do that, and as I plan with clients, what we typically would do is have title of the cottage held by either a limited liability company or a trust. And we'll talk a little bit about why you might consider either one of those structures or entity structures to hold the cottage. So when you're dealing with this cottage plan, I'll now be going through issues that you'll deal with and that need to be considered in any type of plan. Management. Who manages the property? Who makes decisions on behalf of the LLC or the trust? So if it's an LLC, you typically have a management committee. This committee would operate in a similar fashion to the board of directors. So as you think about it, if it's mom and dad that own the property, they typically will make decisions and it's not an issue. But again, as you add generations of people who have an interest in this property, I'm dealing with a family right now that has some Canadian property. This is like, I think, fourth or fifth generation. There are over 140 people in the various generations that have some form of interest in this property, 140. So you don't typically want 140 people making decisions on, especially like day-to-day decisions and that kind of thing. So you usually have a subgroup of the family making decisions. And again, this is kind of what we're talking about. An LLC would be a management committee. If it's a trust, probably the trustees, whoever you pick as trustees of the trust. So in either case, again, it is far better to have one representative from each branch, going back to that concept I talked about, a branch of the family involved in the decision rather than having 140 people trying to make decisions and getting them all together to make decisions, those kinds of things.
Hey, Mark, so we got our first question from Peter. How long can a trust last?
Well, good question. So legally, there's this concept called rule against perpetuities. And a trust holding real estate would be subject to the rule against perpetuities. So there's two tests. It can last, once the trust is set up, 21 years beyond the youngest living person beneficiary of that trust, or 90 years. So right out of the gate, a trust can last 90 years. Now, if a trust gets terminated, you could just recreate another trust and start that rule against perpetuities over again. But under the rule against perpetuities, which is a complicated concept, old historical rule as it comes to real estate, it's basically a person that's living, the youngest person living at the time plus 21 years after their death. So that's one standard, or 90 years is the other.
Wonderful. Thank you so much, Mark.
Yep. So the founders, if they're creating this plan, will usually decide who will be an owner with regard to the plan and who will be the beneficiary. So almost all cottage plans restrict participation in ownership to lineal descendants of the founders. Again, keep it in the family, typically by bloodlines. So as it notes, this key clause keeps the cottage in the family, and the clause prevents in-laws from becoming members or beneficiaries. The cottage plan will also deal with ownership, or how ownership or the beneficial interest may transfer. Let me go back on this. May have missed something. Okay, so again, you open it up typically where a transfer of the interest can go down to bloodlines. So down to again, either ownership itself or beneficial interest would stay within the family lines. Most plans we have deal with an exit strategy or an exit plan. If you have as you pass the cottage down generations, remember, keep in mind that, you know, not everyone may use the cottage, not everyone may be able to afford the cottage. So you want to, in most cases, allow for a graceful exit, some kind of exit strategy. And so the terms that I use for this in the plans, a put option, where the owner or beneficiary would exercise a put option and have the company or the trust buy its interest. And so the put option would require the company to purchase the interest of those members who want out. And we deal with ahead of time certain issues related to that buyout. We deal with valuation, how it's valued. and payment terms. You know, how the purchase price in a put option scenario would be paid. Call option is similar. What the call option means, if the trust or the company forces a buyout of difficult members. Difficult members may be people who don't pay their fair share, or if there's other challenges, they don't follow the rules or those types of things. And it notes like delinquent payments. And again, our call option deals with the valuation and payment terms. Let me talk a little bit about those concepts. So whenever you have a seller and a buyer of anything, and selling or buying an interest in a cottage or you know, vacation property is no different. The seller wants as much value as possible, and the buyer wants it to be valued as low as possible. So rather than have that fight, if something were to occur down the road, the cottage plan should provide how you determine value. So there's already a set formula, and provide for payment terms. Usually the concept is when people develop these cottage plans, they try to make it as least burdensome as possible to those who want to stay involved, because that's the hope of everybody usually in developing their plan, that everyone in the family will stay involved. They'll all be involved. They'll all use the cottage. You know, they'll all use it as the gathering place, everything else. So in determining the value and the payment terms, you keep that concept in mind. Here, I'll go back to that just for a second. So the value may be based on an appraisal. It may be based on the assessed value. And oftentimes in these plans, they discount the value. Again, because they don't want necessarily the heirs to see this as a valuable asset that they can get money from, but as a resource to be used by the family. So oftentimes we'll discount the value. And payment terms may be over time to make it easier to pay that person exiting off. You know, some 5 years, 10 years, and those are all decisions made by the person putting the plan together. Finances, that's also part of a cottage plan. The expenses typically are allocated to the members of the beneficiaries by their interest, by their sharing ratio of their interest in ownership. Many of these cottage plans call for the preparation of an annual budget, and then they assess, based on the annual budget, will assess a payment amount at the beginning of the year or the season to the owners or members. And sometimes people are fortunate enough in dealing with finances for a cottage where the founders may set up an endowment. And I have clients who do that. They save a certain chunk of money, put that into an endowment that helps defer the cost of the cottage. So again, related to this financing issue, that oftentimes is the most significant issue with regard to planning and how you handle, you know, relatives if they can't pay or don't pay. Sometimes a plan will have certain sanctions. It could impose a late payment fee and interest. It could there could be a suspension of the use by an owner or beneficiary. It could and also in some cases people elect to have the suspension not only apply to the individual who's not paying, but that individual's branch. It could be immediate suspension of voting rights and or management participation. In looking at this and deciding what to do, the idea of having these rights maybe not apply just to the individual who's not paying, but to the branch, is because then the branch kind of imposes these things on their own, normally siblings or their nieces and nephews or that kind of thing, rather than have, you know, another side of the family try to apply pressure to pay and those kinds of things. So if the branch could lose rights, well, then the branch might find a way to satisfy the debt at the branch level. And the most significant potential sanction, if you want to call it, for a failure to pay could be this triggering of the call option that I talked about, where you basically force a buyout of the person who's not paying. And again, that's kind of the ultimate, because basically you force them out, buy out their interest, they're no longer involved. So let's talk about, again, the concept of helping the next generation afford the cottage LLC or the trust. Again, the endowment. Many clients endow a cottage with a dedicated fund of money. Let's assume $500,000 invested at 5% would create a pre-tax return of $25,000 a year. And oftentimes this sum may be sufficient to cover the maintenance and operations of a cottage on an annual basis. The endowment may be held and managed by a bank trustee or by the LLC. And again, the endowment distributes to your descendants if the cottage is sold. So if you ever sell it, then that money or pot of money that was endowed may be distributed to the descendants. And the founders, if you're at that level, may want to consider a second to die life insurance policy to fund an endowment. Those policies are relatively inexpensive, and it could create this money that might help carry the cost of the cottage down generations. I just point out that in budgeting for the cottage's future, I do have a Excel spreadsheet that you could go to on our Cottage Law website, www.cottagelaw.com. So scheduling, how do you handle scheduling? Well, there's two different approaches, and a lot of it will depend upon how big the property is, how many people it can accommodate. But in scheduling, there's the rooming house concept or usage where everybody can come and share it at one time. And there's the time sharing approach or concept where you allocate specific time slots to the owners, and you have a mechanism for allocating and selecting those. Here's an example of a time sharing formula where if you had 3 branches, again, based on our initial example, you'd have 3 children creating the branches, siblings, and you just set up potentially this mechanism for selecting. You know, branch A would get the first choice in year 1, branch B second choice, branch C third choice, and then you reverse it in year 2. And by the end of year 3, everyone either had the first choice, second choice, or third choice. So oftentimes I'll have clients who will use something similar to this to manage the scheduling. Here's another example, time sharing formula with multiple branches. Again, here you have 6 branches, so 6 potentially different branches that you're dealing with, and how you might again allocate the sharing of time for usage of the property. So this is just a note on planning that what I just talked about were developed for the LLC approach to property ownership and management. But because of this uncapping issue and the recent changes in property tax laws, I use for Michigan, planning for Michigan clients, I probably use a trust probably 75 to 80% of the time, because from an uncapping standpoint, trusts are much more attractive. And so in my planning, I've kind of taken the LLC concept and used that same concept in trust. The language is very similar. But the use in trust can be a little more complicated, just because it's not necessarily put out there by statute. So that's just a issue that would apply when we use a trust for planning. So when do you create the Cottage LLC or trust? Do you do it immediately during the founder's lifetime? So if they set up this LLC, do you fund it immediately? Or if you want to use, and you would typically do it immediately if you want to use your gift tax annual exclusion amount, or you want to minimize estate tax. You'd finish the gifting during the parent's lifetime if you want to transfer that out of the parent's estate for estate tax purposes, or gift it during lifetime. And you'd also be immediate, you create it immediately if the cottage is owned by siblings or cousins as tenants in common. So if that's the case you have right now, you would probably want an immediate, you'd want to set up the trust or LLC immediately and transfer the property into the trust or LLC immediately. You could also create the Cottage LLC and fund it with the property at the founder's death. This is called a springing LLC. And again, if you do this, you want to make sure that this method is integrated with the founder's estate plan. And you would typically add an operating agreement for the Cottage LLC to a founder's revocable trust as an exhibit, and provide that the LLC is not formed until the death of the second founder. This allows parents at the founder level to retain control for lifetime, but establishes a plan so that the children may share the cottage in the future. So the founders establish a plan, but aren't governed by it yet. But once they transfer the property now down to children, the plan springs into place, so to speak. That's why it's called a springing LLC or springing trust. So let's kind of recap that planning. The LLC or the trust offers the best approach to cottage planning. There's no single or right solution for every family. Don't strive for perfection, because you may never come to agreement, and then you still, again, leave it out there without having a plan in place. Don't expect miracles. Don't necessarily plan for too many generations. Get the plan in place. Think about planning for the next 1 or 2 generations. And a reasonable plan is better than no plan at all. Let me kind of discuss how I work with clients and how we develop this plan. So typically, once I'm engaged to assist with developing a plan for a client, we will get a lot of background introductory information related to the property, related to the family, family tree information, those types of things. And once I have that, I will talk to the family, whoever the family wants to participate. I'll do a telephone conference with the family, and now I can do a Zoom conference if they prefer that. But oftentimes, the members of the family I'm planning with live throughout the country. You know, if they have property in Michigan, but now next generation they've moved, and so I may have up to 10 people in that family that participate. And as part of that process, or in that the process of planning, you know, I will go through a very detailed outline and checklist of all the issues I discussed: management, how costs are shared, who can be owners of the property, again, the exit strategy on valuation, on terms of buyouts, scheduling of usage of the property. Again, we'll go in detail on each item of that and discuss it. And no plan is the same. Plans may be similar, but every family has different ideas as they plan with regard to all those types of things. So we will deal with, those things from that perspective. And these plans are individually tailored to each family and what they want, how they want to handle it.
Hi, Mark. So we have another question. Could you explain more about the nature of trusts? So going before on the last slide, who typically are the trustees?
Yeah, so great question. So normally, again, the most common way that I've handled this is a representative from each branch would be a trustee. So again, if you go to that branch concept, initially the founders or the creators of this trust, or the founders of at the parent level, they would probably both start out as trustees. And then when they no longer can be a trustee, whether because of incapacity, death, or those types of things, then the trustee, then again, it would go down to the next generation at that point, the property or the beneficial interest in the property. And normally we would have, again, a representative of each branch be a trustee. So all the beneficiaries aren't trustees, but we would have we'd have one trustee for each branch. So trustees then are normally members of the family.
Okay, great. Yeah, thank you so much.
Yeah. So that concludes basically the formal part of my presentation, but I'd be more than happy to entertain any questions. If you wanted to unmute, you could ask the question so everybody could hear it, or you could type the question to Eric's, as some of you have been doing in the chat function.
Yeah, I'm going to unmute you.
Yeah, so go ahead. I believe everyone should be close to unmuted. If not, I think you can hit the button yourself. But yeah, go ahead and ask Mark any kind of questions that you may have, or if you want to type them myself, either way.
Okay, Mark, is it possible to have our sons on the title of our property before our death?
Yes, and yes, well, you could do two things, I think. You could put them on the title. The difficulty is what that looks like, because if you list everybody, you could list everybody as tenants in common, or do you do it as joint ownership, or joint ownership with rights of survivorship? Typically, the idea is not with rights of survivorship, because then basically the last son standing, so to speak, his family owns it. So you would normally then do it as tenants in common. And how do you structure tenants in common with the parents? So it's a little awkward doing it that way. Another way it can be done is this concept of a ladybird deed. And this is kind of where the parents retain a life estate, right to sell, all the rights you normally have, but you transfer it to yourself and your kids. And then this deed, so-called ladybird deed, then would say that on the death of the parents, mother, father, husband, wife, that it would go down to the kids as tenants in common. That's another way you could do it, where you put them on a deed during your life. But there are some complications in that. But I think the ladybird deed would probably be a better way to handle that than a deed where either you're all tenants in common, or your rights of survivorship, or those kinds of things. Other questions, other issues? like me to cover? There's some background. If there's background in your thing, if you put it on mute, we wouldn't be able to hear that.
Yeah. So, yeah, if anyone else has any other questions. Oh, here we go. Okay. My wife and I own rental property that is in an LLC with us as equal owners. Can we add our son to the LLC as a 50% owner with us as 25% each with no inheritance or property tax consequences? Mark, also, if you click the chat, I know that was a long, little longer one. So if you click the chat, you should be able to, you'll be able to see that.
Okay. So rental property, here's the issue with rental property. Only residential property applies for some of these exemptions for uncapping, but in particular to your situation, you can transfer up to 50% interest. So if you wanted to add your son on the rental property as a 50% owner, you can give him up to 50% and there would not be an uncapping of the property tax. The next transfer though would trigger an uncapping. So if mother or father add the son, each give him a 25% interest. So now they each own 25, he owns 50. On the death of one of the parents or any other item that causes a transfer, there would be an uncapping at that point. When you transfer more than 50% in an LLC, an uncapping occurs. So if you only give them 50% or less, then yes, you could do that. You can transfer your membership interest to him during your lifetime now, if that's what you want to do. And just don't go over that 50% threshold.
Mm-hmm. Next question. Do you ever use survivorship option in estate planning, or is this just ridiculous?
Yeah, so I guess it's your intent. What's your intent? I don't think that's the best way to do it for estate planning, just through survivorship, but some people do. I mean, so if you're going to put your property, title to your property, and that's your method of estate planning, and you put it on with a child or two children or whatever, if it's one child, survivorship may work okay, because then and you add a child to a deed, and on the death of the mom and dad, it goes to that child through by law because of the survivorship designation on the deed. But I guess if you have more than one children, the survivorship doesn't seem to work well, right? Unless you want the last man standing to be the owner of that property. If you wanted your kids to own, let's say you have 3 kids and you want them each to own a third, survivorship doesn't work. And so you'd have to, again, probably do like the ladybird deed I discussed or something like that to designate that they're getting the property as tenants in common, because survivorship wouldn't really work that way.
Mm-hmm.
So it has its challenges. In some circumstances, it might work okay. But in most cases, survivorship makes it difficult if you wanted your children to share it equally.
And so as a follow-up to the previous question about the 50% owner, like transferring to the son, and then I'll answer Pamela's question, or I'll ask Pamela's question. If the actual value and SEV are close in value, it would make sense to transfer it now to uncap it with minimal consequence?
Yes, I would say yes. If the taxable value and the SEV are close, so there's not a lot of issue, and so there's not uncapping won't cause significant costs. If you do it now to your son, then that's an uncapping event, and now your son can hold it, and there won't be an uncapping until another 50% gets transferred sometime down the road. So yeah, if there's not a big gap, you may just want to do it now, get that uncapping done, and then so then your son holds it for his lifetime, if that's the intent and that's what he wants to do. And so another uncapping wouldn't occur until that happens. So I would agree with that. And over time, there's a potential that the gap's going to grow.
Right.
So if there's not a big difference, do it now. That would be a good plan.
Does a ladybird deed prevent uncapping?
Yes, right now under current law, and remember, I'm talking, when I say these things, this is all current law, and unfortunately, laws can change. But yes, a ladybird deed, it's basically a enhanced life estate, and there's an exemption under setting up the ladybird deed. There's no transfer legally, so that doesn't cause an uncapping. And then on the death of the parent, if it goes down to a child, that child is exempt for uncapping purposes, so that would not cause an uncapping. The transfer within the ladybird deed of down to the remainder, would not cause an uncapping, as long as it's within the relatives that I discussed, and a child would fall within that.
Okay, great. Thank you. If there are any other questions? Do cottage plans make any sense for folks with a single child, or is this something the child should handle later?
Yeah, so that's a great question. The issue, two thoughts on that. Number one, if the child takes it and handles it later, that's certainly an option. But if the parents want input on a plan and they want to have their input in developing a plan, then they should probably do it now. But certainly you're not going to have issues while there's a sole owner, but those issues may arise, if your child has more than one child. So it could start at that level. So certainly you could, what I call, and don't take this in a bad way, but kick the can down the road, so to speak, and just leave it for your child to plan and do that. Again, it just depends, I think, on whether you want input now, and then you probably have your child participate in that input. I've had a number of people do it with 2 children. I don't think I've ever had someone do it with 1 child. So that certainly could wait till, and he could do it at that point in time.
Right. Yeah, thank you. Yeah. Thank you, Mark.
Anything else?
So, all right. Yeah, I just want, once again, thank you again, everyone, for taking time out of your busy day, and to listen, to Mark. I will send out an email to everyone, tomorrow, sometime after, just have to edit this video and stuff, and then I'll upload it to, YouTube, and, share a link. But besides that, yeah, if there are any other questions or comments or anything, let us know, but, we hope that everyone has a wonderful rest of your day. Oh,
thank you again. Thank you for the opportunity.
Thank you.
yeah. Mark, actually, one question. Can ownership of an LLC have a child added at 50% and their children as partial owners with no consequences?
So if I understand the question, you can add a child at 50%. If you transfer down to that child's children, any more percentage, you're out. If you're just talking about that 50% going down to the children, so the 50% to the child does not result in uncapping, but that 50% going down to children, let's say something happens to that child, then you would be over 50% because that's a subsequent transfer, and it's cumulative of all transfers. So if the child takes 50%, no uncapping. If the child's 50%, he subsequently uses that same 50% and transfers to his children, uncapping would occur.
All right, perfect. How about transferring the LLC to a trust? Would that let things stay in the family generation to generation without uncapping?
Okay, so that's a good question. I've thought about that. And I'll answer this two ways. Legally, so if there's property within an LLC, well, there's rules out there or interpretations out there that if there's an LLC and an LLC, and the inner LLC owns property, and there's transfers of the outside LLC, that is actually, and you go over the 50%, that impacts the inside LLC. So I've never had a specific ruling or determination if it's in a trust. But my fear is that you put an LLC in the trust, and if the beneficial ownership of that trust changes over 50% at some point, that the assessor could take the position that causes an uncapping inside that inner LLC. As a practical matter, and this is incumbent upon the people who are involved with the trust, I don't know how the assessor ever knows if the property is always in the name of the trust, how the assessor will ever know that there's been a change in beneficial ownership within that trust. So having said that, there is an obligation, theoretically an obligation on you to report a change of ownership within the trust that might trigger uncapping. I've never seen anybody voluntarily offer that information, and I've never seen an assessor dig into this, who's the owner of the trust now, to determine an uncapping. I can't say that wouldn't happen, but I don't think it works by putting the LLC into the trust, because the change of beneficial ownership in that trust on the outside potentially will, once it goes over 50%, could impact that LLC. So that's the potential issue with that kind of a structure.
If the trustee beneficiaries are the same as LLC owners, would that then make it uncap, or that wouldn't uncap?
Is this a continuation of that one question?
Yeah, a continuation of that question. Yeah. So if the trustee beneficiaries are the same as LLC owners, that
well, the idea is maybe the solution is to transfer the assets out of the LLC to a trust. And
yeah, I mean, I think
the
I've been doing
current owners are still there.
Yeah, I've been doing a lot of that lately, where we've transferred out of the LLC because people don't like this rule on uncapping. I will tell you, early 18, there was a case in South Haven with a family that they transferred the property out of the LLC, I think to do this kind of planning, and the local assessor, so this would be in South Haven, the local assessor fought it and said an uncapping occurred, even though there's some guidance in the state tax commission guidelines on uncapping that says as long as it comes out of the LLC to the same person that put it into the LLC, no uncapping should occur. The Court of Appeals agreed with the lower court that an uncapping occurred. So we're fighting this now with assessors throughout the state. Some assessors are saying if it comes out of the LLC, it's not an issue as long as it goes to the person who put it in. Some assessors are saying that's an uncapping. In this particular case in South Haven, it costs the family $30,000 a year in increased real estate taxes. So they had not had an uncapping in a long period of time, and the property, obviously, on Lake Michigan, was very valuable. But they fought it to the Court of Appeals because of this $30,000 a year cost. I'm now working with that family and doing some planning. I didn't handle the case or the issue on the initial uncapping, thank goodness. But yeah, so the law is in a state of flux right now on reversing things out of an LLC. I'm still working with clients in areas. I typically ask the assessor in advance, if we transfer this out of the LLC, is an uncapping going to occur? There are still some assessors who are saying no, that won't result in uncapping. So I try to get clarification on that before I take it out of the LLC, because I don't want to inadvertently have an uncapping. But I'm working with a number of clients who are reversing that now and putting it in a trust instead in Michigan with regard to Michigan property. So good question, kind of complicated area right now.
If the child owns 50% of the trust, will the property be uncapped when the parents pass?
So the trust doesn't have that same rule, remember, unless you're talking about an LLC. This 50% rule only applies to entities, corporations, LLCs, limited partnerships, those types of entities. With a trust, you can transfer 100% interest as long as it's to that family relationship, son, daughter, grandson, granddaughter, brother, sister, as long as it applies to those relationships that I talked about early on. You can transfer 100% of the trust at least down 2 generations. There's a question whether once it gets to the 3rd generation, whether uncapping will occur. I think you can reshuffle to a certain extent, have it in a trust still, and then and carry that on indefinitely. But I've not done that yet. I haven't lived that long to go down 3 generations, and I haven't had anybody who's done that to see if it causes issues. But I'm of the opinion with a trust, it can go on forever. You just might have to reestablish the trust at that at the 2nd generation. And then again, it goes down 2 generations, it can keep going. But the trust, the 50% doesn't apply to the trust, only the LLC. Okay. Again, I appreciate the opportunity. Certainly reach out. I think my contact information is on there. If you have other questions you'd like to talk about, certainly you can call me, or probably easier to email me, and then I can set something up to talk to you about it. And obviously, if you want to do some planning, let me know. I'd be glad to help you. So thanks for the opportunity, and enjoy the rest of your day.
Yeah, thank you, everyone. And then I'll also include in my email tomorrow, I'll include additional resources as well to the Cottage Law website, and then also to our Fraser Law Firm website too for the cottage planning. So once again, thank you, and have a great rest of your day.